Hi, everyone. Welcome to APALSA's 16th Annual Korematsu Lecture. My name is Sarah Sue, and I'm one of the co-chairs for APALSA. The other co-chairs in the audience, Stephanie Kim. And we're so happy to be caring for the Korematsu Lecture Series this year to talk about important issues to the Asian Pacific American community and to Asian American perspectives on the law. Thank you all for coming out to support and for being part of this dialogue today. I would like to especially thank Julian Wang, who is our Korematsu chair, and he made tonight happen, and he has been working on it night and day. And we would also like to thank the Honorable Pamela Chen. We are so honored to have you here to speak with us, and we're excited about the theme. The theme today that we'll be exploring is race consciousness in affirmative action, and it couldn't come at a more important time in our nation and in front of the Supreme Court. So thank you again for coming, and welcome.
Thank you, Sarah. So I'm Julian, Korematsu chair, also known as the guy who's been bombarding you with emails and Facebook events. We're honored to have amongst ourselves today federal judges, law school deans, staff, faculty, lawyers from prominent firms and the public sector, and of course, students and young professionals like myself. Thank you all for being here. The Korematsu Lecture Series was founded in honor of Fred Korematsu, a Japanese internment challenger. And in that spirit, we intend this event to provide a forum for open dialogue with other groups on important issues, for bridging gaps, and to honor Asian Americans who have substantially contributed to the law while blazing paths. And that's why we're glad to thank especially the Honorable Judge Pamela Chen for accepting our invitation as guest speaker and for her incisive and thought-provoking speech. I read it. We'll also like to welcome NYU Law Dean Trevor Morrison for giving introductory remarks. So without further ado, let's give it up for our very own Dean Morrison.
Thank you. Give it up for the dean. I like that. Okay. Well, good evening. Welcome to all of you. Welcome to this year's Korematsu Lecture. And thanks to the Asian Pacific American Law Students Association, APALSA, for hosting the event. As noted, the lecture is named in honor of Fred Korematsu, really a hero, I'd like to say, in the history of American civil rights. He, of course, is the person whose name is associated with the Korematsu case, which is one of the most challenging episodes in U.S. constitutional history. As a constitutional law scholar and teacher, it's a case that I struggle with every time I have to teach it to my students. And it comes from a challenging time in our history, and so I think it's really fitting to remember Fred Korematsu with this lecture, and each year to look forward to a lecture that will challenge us and inspire us to think carefully and deeply about important issues of law and public policy, and that certainly promises to be true of this year's lecture. Since I'm going to have to run to the next event right after welcoming her, I want to say I want to read the speech, so I'll look forward to doing that. But I am really thrilled to welcome our lecturer this year, the Honorable Pamela Chen, United States District Court Judge for the Eastern District of New York. Judge Chen was nominated by President Obama in early 2013, was confirmed in March of that year, and received her commission on March the 5th, 2013. Before taking the bench, Judge Chen was an AUSA in the Eastern District, and she served in a number of roles during her time there, including as chief of the Civil Rights Litigation Unit, deputy chief of the Public Integrity Section, and chief of the Civil Rights Section. She also did a stint during that period as deputy commissioner for enforcement in the New York Division of Human Rights during 2008. Before that time, she spent time as a trial attorney and as a senior trial attorney in Main Justice in the Civil Rights Division. And before entering public service, she spent time as an associate both at Arnold and Porter and at Asbill, Junkin, Myers, and Buffone, both in Washington, D.C. She's had a distinguished career and brings really, I think, an important voice to important issues of law and public policy. So I couldn't be more pleased than that she is this year's Korematsu lecturer. So without further ado, please join me in welcoming Judge Chen.
thank Dean Morrison. I know he has many things on his plate, but thank you very much for that kind introduction. Good evening, everyone, and thank you to NYU and APALSA for inviting me to be this year's Korematsu Lecture Series speaker. I am honored and delighted to be here. Before I begin my remarks, I want to talk about how I came to pick this particular topic. In 2014, I moderated a panel hosted by the Asian American Bar Association, the president of which we have sitting here, William Wang, or AABNY as it's known. And the panel was on the 2013 Supreme Court decision in Fisher versus University of Texas, which, as many of you know, involved a constitutional challenge to the university's race-conscious admissions process. Now, the members of the AABNY panel included several APA lawyers who had filed amicus briefs in the Fisher case, but those lawyers were on opposite sides of the issue. While the panelists themselves focused in a measured and sophisticated way on the legal and strategic issues in the case, once the discussion was opened up to the audience, and this was a lunchtime panel, all lawyers and law students, mind you, it became quite heated, emotional, and personal. And it revealed a significant and highly charged divide between those in the APA community who support the continued use of race as a factor in school admissions and those who strongly oppose it. For me, the panel was an eye-opener. Though I was aware of the growing debate within the APA community on this issue, I was surprised at the ferocity of that debate. And I was surprised at how active APA lawyers and organizations have become in the fight against policies that historically have been viewed as aiding and assisting and benefiting APAs. Now, the Fisher panel made me realize just how polarized the APA community has become over this issue. At one end, there are those who believe that consideration of race in school admissions has resulted in APA students being denied admission to elite schools solely because they are overrepresented in these schools, and that APA students are being required to achieve higher academic scores in order to gain admission to these schools. There are those who dispute these facts. And then there are still others who believe that regardless of whether these facts are true, the APA community has a moral obligation to support programs that benefit other minority communities, and especially those within our own APA community who are more disadvantaged, like recent immigrants. These proponents of affirmative action also argue that beyond school admissions, the APA community has an interest in protecting race-conscious policies that will benefit APAs in many other areas, such as employment, where APAs continue to experience discrimination breaking through what is often referred to as the bamboo ceiling. Now, given that the Supreme Court is now revisiting Fisher, the topic seemed particularly timely and relevant. Now, to provide some context for the evolving views and the current debate within the APA community on this issue, a brief overview of the relevant case law and legislative efforts is a necessary starting point. And, I apologize, I'm going to drink this water. I have developed this thing, Marco Rubio, when he did that rebuttal I've developed the Marco Rubio affliction. The problem is the bottle is so tall, it kind of blocks my view of everybody. I'm going to work out the logistics here. Okay. This is the difficulty of being a short Asian woman. All right, so the legal battle. Hey there, two of my law clerks, former law clerks. This is all law clerks sitting here in front if you want to talk to anyone about law clerks. Oh, sorry, there's one. The non-Asian one. I'm just kidding. No, I'm totally kidding. Now, the legal battle over whether public institutions of higher education can consider race in their admissions processes began almost 40 years ago, starting with the Supreme Court's decision in 1978 in Regents of the University of California versus Bakke. I'm sure many of you have heard of it if you've taken con law. In Bakke, a white male who had applied for but was denied admission to the University of California's medical school at Davis sued over UC Davis's special admissions program, which set aside 16 out of 100 slots for minority applicants. Only minorities could compete for these positions, and the candidates for the special admissions program were not compared to the general pool of applicants and were not required to meet the 2.5 GPA cutoff that was applied to the other candidates. Now, the Supreme Court, in a 5-4 decision, struck down the special admissions program as violating the Equal Protection Clause. But it held that the university was not prohibited from considering race in its admissions process. Thus, after Bakke, while public schools could consider race and ethnicity in making admissions decisions, they could not use racial quotas or use race or ethnicity to admit minority students who did not meet the school's academic standards. Now, for the next decade, there was a movement to overturn Bakke and to undo affirmative action in school admissions. In 1992, several white plaintiffs filed a lawsuit challenging the University of Texas Law School's affirmative action admissions program, which used a preferential system based in part on a lower academic threshold to admit greater numbers of Black and Mexican American students. In that case, Hopwood versus State of Texas, the district court found that affirmative action programs were still necessary to overcome the effects of a lengthy history of pervasive racism in this country, and held, based on Bakke, that the university could use race as a plus factor. The court, though, ultimately found that the university's use of race was not narrowly tailored because, like the admissions program in Bakke, it used race as a plus factor to insulate minority applicants from being compared to all other applicants. Thus, the district court in Hopwood held that the constitutional infirmity of the admissions procedure is not that it gives preferential treatment on the basis of race, but it fails to accord each individual applicant a comparison with the entire pool of applicants, not just those of the applicant's own race. So the case went up on appeal, in part because the district court denied some of the relief sought by the plaintiffs, even though the district court had ruled in the plaintiffs' favor. The Fifth Circuit reversed and remanded in a very stunning way. It rejected the district court's conclusion that the consideration of race could ever be constitutional, and broadly and unequivocally held that the university could not use race as a factor in its law school admissions for any purpose, not to achieve a diverse student body, not to combat the perceived effects of a hostile environment at the law school, not to alleviate the law school's poor reputation in the minority community, and not to eliminate any present effects of past discrimination by actors other than the law school, for no purpose whatsoever. In a subsequent appeal in Hopwood, the Fifth Circuit reiterated and doubled down on its holding, basically saying the University of Texas was enjoined from using racial preferences for any reason, despite Bakke's holding that racial preferences were constitutionally permissible in some circumstances. The Supreme Court denied cert in Hopwood, thereby leaving the Fifth Circuit's rulings in place. Now, in addition to litigation, there were also other measures used to defeat race-based admissions programs. Following the Fifth Circuit's decision in Hopwood, the California legislature, how many of you are from California? Okay. The California legislature in November 1996 adopted Prop 209, which amended the state's constitution to forbid any consideration of race or ethnicity in public decision-making, which included state school admissions. Despite several challenges, Prop 209 is still the law in California, and in 2014, the Supreme Court affirmed the constitutionality of such voter-enacted laws prohibiting the consideration of race in state school admissions programs. Now, almost immediately after the Fifth Circuit rendered its decision in Hopwood, 2 lawsuits were brought in 1997 against the University of Michigan, my alma mater. Gratz versus Bollinger, which was aimed at the university's undergraduate admissions policies, and Grutter versus Bollinger, which was directed at its law school admissions policies. Both cases made their way to the Supreme Court and were decided on the same day, in June of 2003, but with differing results. The court struck down the University of Michigan's undergraduate admissions program in Gratz, but upheld its law school admissions program in Grutter. While the Supreme Court affirmed in both cases the holding in Bakke that attaining a diverse student body is a compelling interest that can justify the consideration of race in admissions, it found in Gratz that Michigan's use of a point system for its undergraduate admissions, which awarded 20 points to underrepresented minorities, as compared, for example, to awarding 4 points to someone with extraordinary artistic talent, did not offer applicants an individualized selection process and thus was not narrowly tailored so as to survive strict scrutiny. By contrast, in Grutter, the court found that the law school's use of race was narrowly tailored because a review of each applicant was individualized and ensured that all factors that might contribute to diversity were meaningfully considered alongside race, and because no acceptance or rejection of any applicant turned on any one variable, such as race. Significantly, the court validated the school's interest in enrolling a quote-unquote critical mass of minority students and distinguished that from a quota system or a system designed to ensure racial balancing, which the court reiterated was patently unconstitutional. Now, read together, Gratz and Grutter can be interpreted as affirming the constitutionality of using race as a factor in public school admissions, so long as race is treated as one of many factors to achieve a diverse class or critical mass of underrepresented minority students, and so long as race is not used as a substitute for an individualized review of each applicant. Now, where the consideration of race still runs afoul of the Constitution is when it automatically increases an applicant's chances over other applicants simply because of race. Thus, the stage was set for Fisher versus University of Texas, or Fisher 1. Abigail Fisher, a white female, applied for admission to the University of Texas at Austin for the 2008 class, almost 5 years after Gratz and Grutter were decided. Now, in response to the Hopwood decision in 1996, UT had adopted a holistic admissions program that did not consider race, but instead numerically factored in a variety of criteria relating to the applicant's background to produce a Personal Achievement Index, or PAI, for each student. Some of these personal factors that went into the PAI were whether an applicant grew up in a single-parent home, the socioeconomic condition of the applicant's family, and whether a language other than English was spoken at the applicant's home. Now, also in response to Hopwood, the Texas legislature had enacted a top 10% rule. Anybody here from Texas? All right, so you guys have probably heard about the top 10 rule. That rule entitled all students in the top 10% of every public high school in the state to admission to UT. So they were automatically entitled to admission based on having been in the top 10% of their high school in the state. Now, after the Supreme Court's decision in Grutter, however, UT revised its admission program to reintroduce race as a factor, because Grutter now said it was okay. So they did so only, though, as to those students who were admitted not pursuant to the 10%, the top 10% rule. And it should be noted that about 75% of the students that are admitted to UT come from the top 10% rule. So this is applying to about 25% of the people admitted to UT. Now, this non-top 10% admission system that UT has been using since 2005 is complicated, to be sure. So pay attention, and all you math majors, put your thinking caps on. Under this system, an applicant's PAI, or Personal Achievement Index, is calculated based on 2 essays and a Personal Achievement Score, not a PAI, but a PAS, and with each element accounting for a third of the person's PAI, Personal Achievement Index. Now, the PAS, in turn, is calculated based on 6 factors: leadership potential, extracurricular activities, honors and awards, work experience, community service, and special circumstances. The special circumstances component, in turn, is calculated based on 7 attributes, one of which is race. Thus, as the university wrote in its brief in Fisher, race is one of 7 components of a single factor in the PAS score, which comprises 1/3 of the PAI, which is one of 2 numerical values, PAI and AI, which is the academic index, that places a student on the admissions grid from which students are admitted in groups. Okay, everybody got that? Okay. In other words, the university argued, race is a factor of a factor of a factor of a factor in UT's holistic review process. This is the argument they made to the Supreme Court in Fisher 1. Apparently, you do have to have an advanced math degree these days to be a school admissions administrator. But according to UT, the complexity of this holistic formula makes it impossible to tell whether an applicant's race was a tipping factor in gaining admission to the school. Now, when Abigail Fisher was denied admission, she sued the university, alleging an equal protection violation based on the university's consideration of race as a factor of a factor of a factor of a factor of a factor. The district court ruled in favor of the university on summary judgment. The Fifth Circuit affirmed, finding that Grutter required courts to give substantial deference to the university, both in defining its compelling interest in diversity and deciding whether its its specific plan was narrowly tailored to achieve that goal. In a 7-1 decision, with even Justice Sotomayor ruling with the majority, the Supreme Court reversed the Fifth Circuit. Writing for the majority, Justice Kennedy began by reiterating 3 principles established in Bakke. First, that any racial classification, including benign racial preferences, were subject to strict scrutiny. I could never say that one, strict scrutiny. A standard that I note was first articulated in what case? Anyone? Korematsu versus the United States, obviously the namesake case of this lecture series. Second, that the interest in the educational benefits that flow from a diverse student body constitutes a compelling interest that could justify the consideration of race. So you could justify using race to achieve a diverse student body. However, redressing past discrimination does not justify the use of race. That was established then in Fisher. And third, that this interest in a diverse student body is a complex one, and it's not about simple ethnic diversity or guaranteeing that the student body is comprised of a specific percentage of members of selected ethnic groups. That would be racial balancing. Rather, Justice Kennedy wrote, the interest in diversity encompasses a far broader array of qualifications and characteristics of which racial or ethnic origin is but a single, though important, element. The court next explained that Gratz and Grutter endorsed the precepts established in Bakke, including the strict scrutiny requirement that the school's admissions program be narrowly tailored, namely that the program was necessary to accomplish the goals of diversity. The court also reiterated its holding in Grutter that to be narrowly tailored, a race-conscious admissions program could not be used as a quota system. So applying these standards, the Supreme Court held that the Fifth Circuit had given too much deference to the university's justification of its race-conscious admissions program and had failed to conduct the necessary inquiry into whether the program was narrowly tailored to achieve the educational benefits of diversity. The court, in effect, found that the Fifth Circuit had improperly relied upon the university's good faith in justifying its use of racial classifications. Well, Fisher is now back before the Supreme Court. On remand, the Fifth Circuit again upheld the university's race-conscious admissions program, and the Supreme Court granted cert to determine the correctness of the Fifth Circuit's strict scrutiny analysis. I think I'm just not going to say that. You know what I mean, strict scrutiny analysis, and whether the university's program is constitutional. The court heard oral argument in Fisher 2 on December 9th, 2015. So that decision is pending right now. And in fact, it will be decided with only 7 justices because Scalia is no longer here and Justice Kagan recused herself. So where do we in the APA community, and I use that term, of course, knowing that we are far from monolithic, but where do we in the APA community stand right now on the issue of race-conscious school admissions policies? And how do we get here? And how divided are we? Now, although these provide only a partial answer to these questions, the amicus briefs filed by APA organizations in each of these cases gives us an idea of where the APA community has been on this issue and where we may be heading. Now, starting with Bakke, only one APA organization, the Asian American Bar Association of the Greater Bay Area, filed an amicus brief, and it was in support of UC Davis and its race-based special admissions program. In supporting UC Davis, the Asian Bar argued that the special admissions program was the least intrusive means to achieve the compelling interest of compensating for historical anti-Asian discrimination and increasing minority representation in the student body and the medical profession. And here's some of what they argued. As a distinct racial minority group in the United States, Asian Americans have endured a long history of invidious racial discrimination. This prior history of discrimination, both de jure and de facto, was particularly evident in regard to education and employment in the professions. In light of this notorious discrimination against Asian Americans and other racial minorities in the United States, the university was justified in adopting a remedial special admissions program, the purpose of which was to compensate for such prior discrimination. So at least as reflected in this amicus brief, the APA community in the late 1970s appeared to support affirmative action and the consideration of race in higher education. as a necessary remedy and compensation for the effects of historic racism and discrimination against Asian Americans. Now, by the time Grutter and Gratz reached the Supreme Court 30 years later, in 2002, members of the APA community began to side with the non-minority plaintiffs in these cases, pointing to the allegedly negative impact of race-conscious school admissions policies on Asian Americans. Dozens of APA organizations filed amicus briefs in Gratz and Grutter, though the vast majority of these were still lined up behind the school and its race-conscious admissions program. Now, one such amicus brief, which was filed in support of the university, was filed by a broad coalition of the most established APA organizations at the time, which included the National Asian Pacific American Legal Consortium, the Asian Law Caucus, the Asian American Legal Defense and Education Fund, and the Asian Pacific American Legal Center. I'm going to quote a little more extensively from the brief that they filed because it sets forth several arguments that remain at the core of the pro-affirmative action side of the current debate within the APA community. They wrote, Asian Pacific Americans bring a unique perspective to this case. Unlike African Americans, Hispanics, and Native Americans, Asian and Pacific Americans are not specifically identified as underrepresented minorities in Michigan's race-conscious admissions procedures. Nonetheless, amici and their Asian Pacific American constituencies support Michigan's race-conscious approach. Amici do so in spite of the contention of petitioners and their supporters that Michigan's affirmative action programs victimize Asian Pacific Americans. Amici submit this brief to rebut that contention. First, Asian Pacific American students, like all students, benefit significantly from Michigan's race-conscious admission procedures. Ample studies have shown that exposure to students from a wide range of backgrounds enhances the educational experiences of all students, whether Caucasian, American, or minority. Second, Michigan's admission procedures are not rigid quotas, but rather are flexible processes that allow consideration not simply of whether an applicant is African American, Hispanic, or Native American, but a variety of factors that reflect unique background or distinctive personal circumstances. Third, empirical evidence refutes the suggestion of petitioners and their supporters that Asian Pacific Americans would gain from affirmative action's demise. For example, following the abolition of affirmative action programs in California during the 1990s, Asian Pacific American enrollment in state law schools did not increase significantly, as one would have expected if Asian Americans were actually being victimized by these programs. And lastly, they emphasize that at all other schools and in all other contexts, such as employment and public contracting, Asian Pacific Americans should be included in the category of underrepresented minorities in affirmative action programs. And they make the argument that these programs are necessary outside of schools to benefit APAs who are still experiencing discrimination in employment and other areas. Now, in Gratz and Grutter, we see the rift within the APA community begin to emerge and take shape. Against the sea of APA organizations siding with the university, a single Asian American organization, the Asian American Legal Foundation, or AALF, and you'll hear that name a lot, filed an amicus brief supporting Gratz and Grutter, the plaintiffs in this case. They argued that the university's use of race violated equal protection and raised the specter of racial quotas and Kafkaesque social engineering. AALF cited to the experiences of Chinese children in the San Francisco public school system, which limited percentages of students by ethnicity in each school and resulted in Chinese students, because of their overrepresentation, being capped out and denied admission to the city's best schools. AALF maintained that the use of race-based quotas penalized Chinese applicants for their ethnicity and success, arguing that there is no difference between a policy of admitting some people because there are not enough of their race and a policy of excluding others because there are too many of theirs. AALF also challenged the university's assertion that achieving racial diversity in the student body was a compelling interest. And they argued that instead the only justification for using race was to remedy past discrimination. Now, along comes Fisher 1, which was briefed in 2012. Here we see the divide within the APA community grow and become much, much more public. A Reuters article published in August 2012 summed up the situation this way. On Monday, dozens of Asian American organizations filed amicus briefs at the U.S. Supreme Court arguing that universities should be allowed to consider race in admissions decisions. 5 Asian American groups were not among them. That's because those groups already filed their briefs in the closely watched University of Texas case on the other side. They argued in May that the school's race-conscious admissions policies hurt Asian Americans by giving less qualified candidates a leg up on admissions. The dueling briefs provide stark evidence of a growing rift within the Asian American community over the role race should play in college admissions. The split could have implications for how the court resolves one of the hottest cases on its docket this term. One professor said the views of Asian Americans as expressed in the amicus or friend of the court briefs could take on added significance in the court of public opinion and perhaps with the justices themselves. The professor went on to comment that the traditional justification for affirmative action has been to prevent schools from becoming all white. That rhetoric becomes more complicated once you recognize that race-based systems discriminate against Asians as much as whites. There have been pockets of resistance to affirmative action among Asian Americans for years, but the rift, this article reported, has gotten more pronounced in the Texas case, which prominently features the impact of race-based admissions on Asian Americans themselves. The article concludes with the plaintiff's main brief challenging the University of Texas's affirmative action plan mentions Asian Americans 22 times and argues that they are victims of a race-based system that favors blacks and Hispanics. In Fisher 1, many of the same APA organizations that had supported the University of Michigan in Gratz and Grutter joined together to file 2 separate amicus briefs supporting the university once again. In addition, the National Asian Pacific American Bar Association joined forces with the National Black, Latino, and Native American Bar Associations as part of the Coalition of Bar Associations of Color to file an amicus brief in support of the university as well. These amici who were supporting the university assailed Fisher's treatment and distortion of the APA community as monolithic and as the model minority that had overcome discrimination. And they argued that there were many subgroups within the APA community who still faced discrimination and benefited from UT's race-conscious admissions programs. These amici also disputed the central claim of petitioner and the APA amici supporting her that the enrollment of APA students at UT was being suppressed because of UT's race-conscious admissions policies. These amici cited statistics showing that APA students were being admitted at the same rate whether there were race-conscious policies or not. The amici also disputed the notion that APAs were being subjected to an admissions penalty, a penalty requiring them to score hundreds of points higher the other side on their SATs. These amici used data to show that the admission rates and the average SAT scores were the same for Asian Americans, whether the policy was in place or not. The National Asian Bar took a slightly different tact, and basically in the Coalition of Bar Associations of Color brief, essentially argued that diversity was important for all races, that policies to promote diversity were important to all races and ethnicities in our educational system, and that it was a necessary pipeline to support diversity in education for individuals coming into the community to work and all elements of the legal profession as well. Now, the contrary view within the APA community was being represented in 2 different amicus briefs now. One filed again by AALF and the Judicial Education Project, and the other filed by the Louis D. Brandeis Center for Human Rights Under Law, a historically Jewish organization, which was joined by the 80-20 National Asian American Educational Foundation, an organization that claims to speak for the Asian American community based on nationwide surveys that they conduct of the APA community. Now, AALF's briefs argued both that UT's program discriminated against Asian Americans by deeming them overrepresented and thus less worthy of admission than the underrepresented races, and they also argued that APA applicants were being penalized, this penalty we talked about before, by having to score hundreds of SAT points higher than Hispanic and African American applicants in order to gain admission. Now, arguing for the complete elimination of all race-conscious policies, AALF wrote, UT's race-based admissions policies are merely the latest method for the government to pick and choose among the races to the benefit of whichever races are currently in political favor and to the detriment of whichever races are not. They go on to write, while there is no doubt that diversity is valuable, true diversity is found only at the individual level, created by individual differences in ability, experience, interest, opinion, and other personal qualities, judged without resort to the invidious shortcut of racial stereotyping. They go on to say that the program that UT uses is using racial diversity that is literally only skin deep. Sorry. Meanwhile, the Brandeis Center and the 80-20 amicus the Brandeis Center and the 80-20 group in their amicus brief compared the discrimination being faced by APAs in school admissions with the discrimination faced by Jews in the early 1900s. And they wrote, Asian Americans are the new Jews, inheriting the mantle of the most disenfranchised group in college admissions. Now, as discussed in the Reuters article, arguments like these figured prominently in Fisher's own arguments to the Supreme Court. For example, Fisher argued that UT has not, and indeed cannot, offer any coherent explanation for why fewer Asian Americans than Hispanics are needed to achieve diversity, educational diversity. So thus now in Fisher 2, which is before the Supreme Court again, we have the same APA amici lining up on both sides of this debate and making substantially the same arguments as before. In one APA organization's brief filed in support of the university, the amici argued that Abigail Fisher and her amici are attempting to invalidate UT's program as part of a larger effort to roll back all such race-conscious programs. To bolster their ideological challenge, they seek to portray Asian Americans and Pacific Islanders as victims who are categorically excluded and burdened by affirmative action programs. The undersigned amici reject these unfounded claims that APAs are harmed by such programs and categorically oppose such efforts to use the APA community as a wedge group to curtail opportunities for racial minorities. They go on to say that Fisher and her amici peddle a form of revisionist history where APAs achieved educational parity solely by dint of their own efforts and merit. This ignores, however, the fact that APAs historically benefited from the inclusion in race-conscious admission programs, that certain APA subgroups continue to need and benefit from such programs today, and that all APA students benefit from more racially diverse and less racially hostile college campuses. And this is the argument that those who still support affirmative action continue to make at this time. These amici strongly advocated for the APA community to continue to support affirmative action programs regardless of whether APAs directly benefit from them. Now, on the other side, AALF is once again leading the charge in opposing UT's admissions program. AALF has now been joined by the Asian American Coalition for Education, which claims to represent 117 affiliated Asian American organizations. As before, these amici seek to eliminate all race-conscious admissions programs and to have the Supreme Court overturn Grutter. While making the same arguments as in Fisher 1, AALF now does so with a greater sense of urgency and outrage. Its brief begins with the following. Amici are greatly distressed by and find offensive the decision of the Fifth Circuit Court of Appeals upholding the race-based admission program at the University of Texas at Austin. Contrary to that court's depiction of the issue as white versus minority, in fact, it is Asian American students, the members of a historically oppressed minority, who comprise the group most harmed by the program. The evidence and common sense demonstrate that the UT admission program at issue is nothing more than forbidden racial balancing, or even worse, potentially an effort by academic and political elites to curry favor with a powerful voting bloc. Under the Texas 10% plan, UT already had more Hispanic students enrolled than Asian American students, but under the plan being challenged in this case, UT insisted on giving preferences to Hispanic applicants while disfavoring Asian American applicants, demonstrating that the university was not striving for diversity, but racial balance. The AALF amici argue that UT's admissions program amounts to the same type of racial and ethnic discrimination that Asian Americans have faced in the past, especially in education, where Asian Americans are still being classified by race and not considered as valuable because of their race. So, through these APA, and again I'll use air quotes, amicus briefs, we can chart the course of the APA community's views on the use of race in school admissions policies, beginning with the seemingly uniform support of affirmative action programs in Bakke, to the emergence of seemingly widespread and very vocal opposition to any and all forms of race-conscious school admissions policy in Fisher II. Now, what I find ironic is that the argument at the beginning for affirmative action was it was meant to compensate and remedy invidious discrimination against Asian Americans. Well, that argument now is being used to undermine and undo affirmative action, namely to prevent invidious discrimination against Asian Americans. Now, obviously reflected in this shift are the changing circumstances and experiences of APAs in this country, and the success that many in our community have achieved, at least with respect to education. This seeming shift within the APA community away from affirmative action and race-conscious policies has manifested itself most recently and prominently with the filing of the lawsuit by the Students for Fair Admissions, or SFFA, against Harvard. I'm sure many of you are aware of that lawsuit. In that lawsuit, SFFA argues that the school's race-conscious admissions policies are discriminatory to Asian Americans and unconstitutional. The same themes from the anti-affirmative action APA amicus briefs that you've just heard about form the basis of the SFFA lawsuit almost verbatim. Harvard caps the number of Asian American applicants admitted to the school as part of its racial balancing. Asian American applicants are required to achieve substantially higher test scores than all other applicants in order to gain admission. Harvard's admissions program is an elaborate mechanism for hiding its systematic campaign of racial and ethnic discrimination against certain groups. And Asian Americans are being subjected to the same discrimination that Jews faced in the 1920s and 30s from elite educational institutions. Those are many of the arguments that SFFA is now arguing in its lawsuit. The SFFA, that's a really tough one too, lawsuit reflects the culmination of years of growing opposition within the APA community to affirmative action in school admissions, and is perhaps the most direct attack by members of the APA community on race-conscious school admissions programs. Now, when you consider the success that APAs have achieved in many areas in this country, and the corresponding shift in views within our community on the issue of affirmative action, you have to wonder whether we have in effect become the majority minority, and I mean this in many senses, the runaway minority. Should we as Asian Americans be concerned that, as some who have filed these APA amicus brief have argued, should we be concerned that we're being used, almost like a battering ram, to dismantle affirmative action programs? Should we, as members of the APA community, no longer support affirmative action because it might actually cause harm to some people within our community, or because fewer APAs are actually benefiting from it? What does it mean to be a member of the APA community? Are we defined only by the discrimination that we experience from the outside? What is our obligation to protect or help the newest members of the APA community, specifically recent immigrants, or those who are still suffering from disadvantage from discrimination? What is our obligation to support non-APA minority communities who may still be suffering the disadvantages born of prejudice or discrimination, such as the African American community, the Native American community, and the Hispanic community? Should race ever be a factor in school admissions or in any other context? If we oppose using race as a factor in school admissions, how can we justify its use in other contexts, such as employment, where some say APAs are victims of the bamboo ceiling phenomenon. What interests, if any, are properly served by race-conscious policies? Should it be remedying historic discrimination, compensating for socioeconomic disadvantage, combating ongoing racial or ethnic prejudice, and/or promoting racial and ethnic diversity? Is the use of race outdated in terms of achieving one or any of these goals, one or more of these goals? And can these goals be achieved or achieved more effectively through non-race conscious means? One of the arguments made in the Harvard lawsuit is that there are so many other means by which to attack this problem that we shouldn't be using race anymore. And finally, what does diversity mean? This has now been endorsed as an appropriate and compelling interest for schools to pursue, but what does it mean? Does diversity mean achieving racial or ethnic balance that mirrors the general population, or is that just racial balancing? And some of you who live in New York or have grown up in New York know that we're facing this problem, or this issue, I should say, to some extent in the high schools here. Anyone go to Stuyvesant? Okay, anyone go to Bronx Science? Okay, in New York, interestingly enough, there is no consideration of race at all. It's purely testing. And right now, Stuyvesant has a 75% Asian American student population. It's staggering. Is that diversity? You have to ask. What's the proper way to address that issue if we don't think it's diversity? Should Asian Americans be capped in schools? Clearly, the Supreme Court has rejected that in many contexts. Actually, there are a number of decisions against that. Is diversity too amorphous a concept to be a compelling interest that justifies racial classifications? So let me close by leaving you with all those questions. And by urging, I hope you actually didn't think I was going to answer any of those. Not enough time and not enough brain cells, really. But let me close by urging you as the next generation of thinkers, lawyers, and lawmakers to take part in the debate on these important issues and to help shape that debate both within and without the APA community. It's been a privilege and a pleasure speaking to you tonight. Thank you very much. Yeah, okay. Julian, you should know I always bring my entourage to cheer.
Thank you, Judge Chen. We have 2 mics set up on either side of the room for any questions, or you can just shout it out when you're not in an optimal position.
No, none from the front row, that's for sure. Steve, how are you? Another law clerk from our courthouse.
I have a question. You mentioned at the very end that the APA community, air quotes, should have this debate about whether diversity should be used. Where should we have the debate? Should we have it in the courts, like you seem to be stating in all these amici briefs? Does that really make a difference at all? Or should we have it in the legislature? Should we have it somewhere else in the workforce?
I think you should have it everywhere you can. The classrooms, in the bars, in your social settings, in when I say bars, I actually meant the type where you do drinking and also bar associations. So, but all forums, I mean, the bottom line is this is your life, this is your future. These are the issues that should matter to you, especially as lawyers. You have the ability to make change. You have the ability to argue on one side or the other. But you should be having that conversation with whomever you can in whatever setting. But I thought personally when we had the event, the lunchtime panel event, it was a really invigorating conversation because you had a panel of people who really knew the legal issues and could talk about the actual legal debate, and then you had everybody else around who talked about it from a much more personal and informed viewpoint. Because this issue, and for those of you who are literary nerds, does anyone know where the expression within and without, what the most famous literary reference is to it? Okay. Oh, May, come on. The Great Gatsby. There's a great quote from The Great Gatsby which says, "I was within and without, simultaneously enchanted and repelled by the inexhaustible variety of life." And there's much debate about what within and without means. But the reason I use that title is because that is about being sort of a narrator in some way of the scene, of looking at it from the outside, as you as lawyers do. You analyze it from the outside, but also being within it. because this is about your community, whether you like it or not. When I raise the question of what does it mean to be part of the APA community, some of it's by choice, and some of it's just by dint of being Asian, and that's how the world perceives us. You don't really have an option. I mean, you can't really opt out vis-a-vis the rest of the world. So that's why I say from within and without. I mean, think about it as people who analyze the issues, but as well as those who are affected by it. So my not short answer to you is you really should be having that conversation everywhere. You should be having it in your constitutional law class, quite frankly. You have Kenji Yoshino. Many of you are taking his class. I just read his equal protection argument. I was afraid that I would get really hard questions, so I read it. Is a Harvard Law Review article. But you should be asking the question. These are hard issues. What is, and so everywhere you can have it, you should have it. But I think you should join your bar association, the Asian Bar Association. They always have very lively debates on these topics, and you should have it in the classroom, for sure. Sorry, that was a long answer to a short question. Anybody else? And you don't have to ask anything about the topic. You can ask anything you like.
I don't know if I should skip, but, so I'm from Texas. I went to the University of Texas, and I actually went to rival high school as Miss Fisher during the time that she was applying to senior IVA, so we have a lot of mutual friends.
And were you in the top 10 of your high school?
I was.
Okay. There we go.
Sorry, but,
No, I'm just kidding.
sorry, that was kind of, but in terms of just, I'm curious as to how far the Supreme Court will go, and I was wondering what your thoughts are, because the top 10% rule says you can get into the school, but it doesn't guarantee the program that you can get into. So, for example, certain programs in certain colleges, like the business school and engineering school, that have historically been more competitive, have their own admissions policies.
Interesting.
And they may have their own formulas in terms of, and I know that for a fact that they have their own formulas in terms of calculating how race plays a factor in admitting students to certain honors programs.
Right.
So I was wondering how far the court may go in this instance and what.
What will happen in Fisher too, you're asking?
Through
Yeah.
Fisher, right.
No, I knew someone was going to ask that question. Let me just say this. I mean, I guess I have to say this. It's obviously a pending decision before the court, and I'm loath to give an opinion about what I think will happen in a pending case, even though it's not before me. Obviously, I have to look at these issues very neutrally, should an issue come up before me that's similar. But I will say this. I believe it's true that if the Supreme Court strikes down Texas's current program, it will probably be the death knell for consideration of race at the higher education level, because it's hard to conceive of a program that in some ways tries to minimize the effect of race and make it as blind to race as possible. Now, I will say this as a disclaimer. I've read the briefs and I've read some of the amicus and the responses. I don't presume to know all the legal issues, but they've been played out in various decisions. What could happen, especially with Judge Scalia's seat being empty, and I read the oral argument of the second time around, there seems to be a lot of focus, interestingly enough, about can you prove, university, that this consideration of race as a factor of a factor of a factor 10 times over actually has an impact on increasing diversity in the school. And the school's response is partly what I told you, which is that part of this was to not know whether or not race really had an impact. And so it's very difficult, the box they're in. They're being required to show that it actually achieves the purpose and therefore is narrowly tailored, and yet at the same time, if they do trace it that way, it almost becomes a trigger factor that becomes inappropriate. So my view is that it's very possible that the Supreme Court could defer this case until after they have another, until they have a full bench, although then they're going to have an even vote because Justice Kagan will recuse herself again because she was in the administration at the time it was first argued. Or they may decide to send it back to the Fifth Circuit and then tell them to send it back to the district court. Because the other concern they expressed was that there was no trial. It was decided by summary judgment. So there was no factual development on the issues like what impact does it actually have. I could see that happening, especially at this time, without a very strong voice or a strong voice missing, because Scalia was a very solid vote against the affirmative action program. So that may be what happens. It may be kind of a tie that goes back to to be remanded or just kicked over to the next. But I do say that if they vote against it and they decide to vote against it, it probably will be, the death knell, I think. It's hard to imagine a program that, conceals that more.
You mentioned how Asian Americans are not a monolithic group, and I think as a political, talking about Asians as a political group, there's a huge lacking of language in addressing that factor. I wonder, two-part question, I wonder what you think about that, but also whether they're legally, the courts maybe is progressing towards a more sophisticated way of looking at race-conscious decisions regarding Asians and other races that obviously aren't.
Yeah, so did everyone hear the question? The question was APAs, or now AAPIs, I think, are not referred to in a way that's very descriptive and really doesn't reflect the diversity within the culture. And it's interesting because I don't know if you read this article by Professor Yoshino. He talks about exactly that. He calls it the pluralism anxiety. And one of the movements, he says, is that the Supreme Court is moving away from an equality-based analysis to a liberty-based analysis, partly because of this anxiety about pluralism. The notion being that there's so many identity groups out there now and so many subgroups that everyone's going to be clamoring for individualized rights. And you see that played out a little bit in this analysis, right? Because one of the arguments that the APA, writ large, community still makes is there are members of our non-monolithic community that still need this benefit. People from the islands or people who are recent immigrants, et cetera, et cetera. So I think that the Supreme Court is moving away from it. So there probably won't be more of an effort to define these communities more, at least in the jurisprudence. If anything, I think the Supreme Court, I think Professor Yoshino has a very good point. If you look at where the cases are going, and Fisher is a good example, because I think this may be the last time they raise this. When you get to the point that race is like a dot in your analysis, I think there's less appetite to deal with the microcultures within APA. So I don't think it'll get any more defined unless jurisprudence starts to focus more on equality versus liberty analysis, like a human rights analysis. So I think, and there was a second part of your question, I apologize. Was that?
I guess the first part was just what you think about the lack of language surrounding how Asians are non-monolithic and also like income inequality. For example, in Stuyvesant, even though it's 75% Asians, I know I think 50% of Stuyvesant is on
Chinese?
like vouchers.
Oh.
So a lot of the conversation about moving towards a less like a more equal application of essays and stuff like this about taking away a lot of the positions for low income.
Right. Everything you say actually in some way supports a view that we should get away from talking about it as race in a way, which is it's impossible to break down the experiences of people within the APA community necessarily, right? So we could go through a litany of all the different sub-Asian groups, but would that inform the debate about rights or disadvantages or benefits? And I think just as you say, it's interesting that half of the Stuyvesant students who get in are on school vouchers. So maybe that suggests that we should get away from a race discussion because it's not all that useful. And maybe we should identify, this is the question of when should we have affirmative action programs? And I use that meaning race-conscious ones. And should we use other criteria now instead of race? Should it be more about socioeconomic disadvantage to promote that? Your question's a good one, but I don't think there's going to be any greater effort to sort of subdivide groups anymore. I think we have, as Professor Yoshino says, pluralism fatigue, I think, going on right now in our constitutional jurisprudence.
Judge Chen. Just want to answer the gentleman's first question. The Asian American Bar has been doing a lot of work. The year after your lunchtime panel, we had Lee Chang from the Asian American Legal Foundation. We had a very interesting discussion about affirmative action at university admissions. And the question, I've been working on this issue for the Asian American Bar a lot. And one of the questions that I've been wrestling with is for the Asian American organizations that strongly support affirmative action.
Yes.
Are they doing enough about negative action? And in terms, and if you want to, so negative action is sort of defined as if you have a Black and Latino candidate versus an Asian American candidate, okay, we support affirmative action, the Black and Latino candidate will win. But if it's negative action, as between a white candidate and an Asian candidate, if the white person wins, that's negative action. So are they doing enough about negative action?
That's a very good question. And I actually don't presume to know the answer. I don't know, maybe you would know better. I just don't, I think right now, I don't think, let me put it this way, it seems to me the debate is either with us or against us in terms of affirmative action. And I think those who oppose affirmative action feel that they're the ones doing something about negative action, right? That's the view, which is, the argument is it's a zero-sum game. So every time somebody gets a slot who may not be as deserving, it means somebody who's more deserving, in theory, loses a slot. And I think those who are trying to dismantle affirmative action would say they're the ones in the Asian community who are really addressing the negative action issue. And I think that's the most I can say about that. What I will say is that those who still support affirmative action only say that we should continue to support race-conscious policies so long as there isn't any overt or deliberate negative action by schools, such as Harvard. But then you have the Harvard lawsuit, and I think those folks would say they're the ones who are actually making the case against negative action. And let me just say one last thing on that. Though much of what I read in terms of the excerpts focused on Blacks and Latinos getting slots that maybe Asians are not, there was also a focus on negative action, namely Asians still having to score higher, not necessarily hundreds of points higher on the SAT, but higher than white applicants as well. So being treated worse than everybody.
Thank you. One of the questions that you did not want to endanger more brain cells on was that caught my attention was what is diversity, and I've been struggling with this and balancing that with the debt that the APA community basically have towards affirmative action. Just to give some context, I came from a small liberal arts college, Amherst, which has about 400 people in the class, very similar to NYU Law. And back in the 1970s, according to an alum, there were 2 Asian Americans in the entire school. Today, there are about 12%. So Asian Americans. So obviously that's a step forward, and when you have 2 in the entire school, we know that yes, race is probably a factor. But at the same time, for example, a recently retired Amherst chairman of the board is Black, and he is a multimillionaire, if not billionaire, who runs a hedge fund. But yet his kid, if he chooses to apply to Amherst, would still benefit from affirmative action, which is meant to address socioeconomic, historical factors.
Right.
So I guess that's a long way of asking, there are so many countervailing factors. To you personally, what is meant, what does the word diversity mean?
Well, I think in that regard, the Supreme Court cases are really moving in the right direction. And I think to some extent, as much as I was mocking the UT formula, I think they are trying to approximate as best they can diversity. Because diversity is everything, right? It's not just race, gender, ethnicity, wealth, all those things. But it really is sort of the mix of every human experience, right? It's impossible to capture everything, but I think schools do have to have a certain degree of flexibility, and I think achieving that kind of diversity should be left to the administration to some extent. I guess I should be careful. These are my personal views, I should say. But I do think it's very hard to figure out what it is, but I think we kind of know it when we're in it, right? And I think all of you have obviously gotten through college, and you may have had a more or less diverse experience. I went to the University of Michigan, probably predominantly white state school, right? So I would not have called it diverse in that way, but people have to find within that something that achieves the diversity that they're looking for. So, I mean, I think by dint of being large, Michigan is diverse. You're bound to find somebody. It's like New York. But I do think that it is a multi-factored concept. And I do think programs like University of Texas are trying to approximate as best they can some way of taking that all into account without making it overly subjective, which is I happen to like the artist versus the basketball player or something like that. So I do think that people are struggling with it very honestly and trying to get to that, but I think it is everything you can imagine about a person would make up a diverse environment. So it's not just one thing, to be sure.
In Grutter, Justice O'Connor said in dicta that while diversity is a very compelling purpose and objective right now, in 20 years we may not have to address the problem anymore. And given just Professor Yoshino and your observation that we have acidic anxiety, and it would seem to me that it would be an easy way out for the court in the near future to come back to that dicta and say, well, we have achieved or made a substantial step towards racial balance, and therefore we can abandon it in favor of other factors like socioeconomic factors.
Yep.
Do you think that's the direction that the court will go in?
It's definitely a direction, and it's funny you say that because during the oral argument in Fisher 2, Justice Roberts said that. He said there was a comment by Justice O'Connor in Grutter, in 20 years we won't need affirmative action anymore. So that was 2003. We're now at 2015, and he said, well, how about it, folks? Have we gotten to the 20-year mark or not? And so I think it is the burgeoning consciousness of the court, which is that this is a time-limited proposition, and that we have to move away from defining people in some way by race. It does seem to me schools are also trying to come up with these holistic models for considering all the other factors, the diversity factors. So that seems to be the movement both of the schools and certainly of the case law. I think Fisher 2 will definitely reset, I guess, sort of the floor in some way, or restate the direction, or reaffirm what direction this jurisprudence is going in. But I think your observation is a correct one. I think they're feeling it already. Yes?
So, it seems like the bases for affirmative action of remedying past discrimination or diversity aren't super compelling to me. That there are, say, other better ways to go about, even if you do value those things, race is not the best way to view it. And what seems to be the remaining justification, and perhaps is the real and unspoken one, is that some groups generally are underperforming, essentially in like the things that we look at and value in society. They're not making it as far in careers or getting into as good of schools, and we're kind of like, why aren't they behaving at least equal with the norm? And so we're trying to exert some sort of a pulling pressure on that group, trying to get it so that it's, with the equilibrium at a more neutral place.
Right.
But it seems to me like that's not what actually changes group situations. And so my question is going to kind of come back to that. Like I feel like with the Asian group, there was a culture that's an outward pressing one. Like there's sort of cultural values that help the group succeed. It may be like emphasis on education, emphasis on community, that leads to, in the long term, them essentially succeeding and being kind of normalized within that group. You mentioned that there were some affirmative action policies that definitely have helped some students. But I would be surprised if that was the real cause of today's state of affairs, where Asians are, overrepresented, are doing better than whites in a lot of areas. And so what my kind of question is do you feel like the discussion over affirmative action is almost is overemphasized on a symptom, and that we're talking about like, should we pull up individuals from these groups that aren't working hard, or should we focus, right, trying to like pull open the balloon, or should we find a way to fill that balloon by like instilling the values in that culture that are going to be producing and pushing people forward and higher? Is that kind of...
No, everything you say, I think, has been said, and that's not a criticism, by many, which is that, and I'm paraphrasing or I'm interpreting what you're saying, is that part of the problem we're addressing isn't necessarily one that's addressed by these programs, right? The question is, let's take your premise for a moment, that there's some groups that may be underperforming, if you will, but for various reasons, none of which are judgmental in any way. And are we really helping them by, with these programs, as opposed to earlier on instilling something else or changing the circumstances that existed beforehand? This is one of those debates about shouldn't we be addressing the causes of some of the symptoms that we see as opposed to just trying to address the symptoms, right? And it's a legitimate question, and it's one that's many people are debating. I mean, and maybe I'm assuming too much about your question, but things like, the discussion about Head Start and changing environments in inner city schools and trying to give more opportunities for students who are in environments that don't naturally support excelling in school, more opportunities. All of those things are part of the answer, to be sure. I don't think it necessarily, though, it's sort of a different issue. It's a parallel issue, maybe, in a way, to what we're talking about in terms of race-conscious policies at school, which is just another way, admittedly, of addressing what you call a symptom. It's certainly the latest manifestation of the same problem. But some would argue that that's the way to sort of send at least those individuals on a different course to sort of not have that loop continue. That's certainly one argument. And I guess that's what I would say about it. I don't think what you're talking about necessarily informs the other, and some would argue maybe you're right. Maybe this is less useful or less effective. Like when I say this, meaning, trying to help kids get into college who may not be able to, who may not be up to it. That's what you're suggesting. Rather than curing the root problems. That's certainly a legitimate question. I think right now the law, though, allows us, and that's why I think the law now gets to the diversity issue and also says you can't admit people who aren't otherwise qualified to be there, right? So that's sort of some of the underbrush that was cleared up by the early affirmative action between Bakke and then Hopwood up through Gratz to some extent. The idea being you can't just let people in if they can't perform, but you want to consider all the other factors that may at least make the playing field a little more level for them in some ways, or as they were saying, the negative action issue. I mean, if you're going to choose between two people, you may choose a person who has sort of that plus factor. So I don't know if that answered your question.
That's good. Thank you.
Amy's saying I didn't answer that question. This is my partner who's telling me I didn't answer the question. Sorry.
Hi,
How are you?
Great. How are you?
One of our former interns in NYU student.
So nice to see you again here today. I'm taking Con Law with Professor Yoshino this
Yes.
semester, so it's such
Lucky
a,
you.
Yeah. So it's such a delight to hear about your views on his kind of academic studies. And from my
By the way, if
perspective,
anything conflicts with what I say and what he says, you should follow what he
Oh,
says. That's what we say in court all the time.
No, you're totally correct about the article he wrote for the Harvard Law Review. So from my perspective, the court already, I think from my perspective, all the justices on the Supreme Court now agree that blatant racial balancing is constitutional. So there's no reason for any university to use like direct racial balancing in school admission, and I definitely think that is the right way to go. And from my perspective, so Justice Kennedy has always been a swing vote in those in Grutter and in Fisher. Fisher 1, he drafted the majority opinion, and I think the focus of Fisher 2 was also on his interpretation of the University of Texas policy. And from my understanding, the majority of the justices on the Supreme Court think they should pay deference to the objective of those of the school admission process, which is diversity, as we talk about what is diversity. But personally, I agree with this goal, and I identify a lot with its implications. And so Justice Kennedy's another point is that we should pay deference to the goal. We should not pay deference to the implementation of the goal.
Right.
therefore, we should pay more attention to how the school assesses each individual. And it seems to me that is approaching more like individualized assessment program.
Right.
And honestly, I think that's a very good direction, and it would not only benefit the Asian community, but it will also benefit other minority communities, also white as well. And I would like to know your take on Justice Kennedy's position on this issue, and whether this direction towards a more individualized assessment of a school admission process would be beneficial to the APA community as a whole.
Right. Well, certainly personally, I think it makes a whole lot of sense. I think it's the question we discussed earlier about what does diversity mean. I think this holistic, individualized view is a very sensible one, personally. And also as a matter of law, that is the guiding principle these days with respect to equal protection in the context of school admission. So it seems quite sensible. But the question is how you do that. If something like, doesn't the UT system accomplish that? And if not, then what would? I mean, that's the question you're left with, depending on what happens in Fisher too. But yes, I agree. I think it makes a whole lot of sense.
Yes, especially I think the school system should take a lot more like socioeconomic factors into consideration, and I think that transcends racial considerations. And yeah, that's just some of my personal opinions. Thank you.
No, not at all.
So we're going to have time for one or two more questions before reception.
Okay. Yes.
Thank you for being here today. I noticed that I think one of the goals was to address past discrimination, and I'm not as familiar with the legal arguments as I should be, but I was wondering if there's any discussion about current discrimination, because it seems to me like the alternative to race consciousness is race subconsciousness. I think that's something that affirmative action tries to address, not just like things that happened in the past, but things that people can't control themselves from doing today.
Right. No, that's a very good question. I mean, but bear in mind, right now, the way the law is, at least in the context of school admissions, and I think it's true generally, is that remediating past discrimination is really on the run in terms of an interest. You know, starting with the first Texas case, and then obviously in Fisher, they pretty clearly said that that's not at least an interest that the school can remedy. And one of the reasons is that the school's not like a legislative body, and they don't do studies on these things. So they're not in the position to do it. So obviously in other contexts, that can still be dealt with. You see minority business kind of legislation and things like that, and there's always discrimination lawsuits being brought in other contexts. So the long and short of it is, you are absolutely right that remains a problem, and I think to some extent, these some of the laws that get passed by legislatures, I think, are meant to address some of those subconscious biases that people have. And I think the way they bear themselves out is in numbers. I mean, Julian was talking about at Amherst there was only, 2, Asians there, which sort of defies logic. So I think that the best way to address those are still the use of affirmative action, right? In certain contexts, but it has to be very narrowly focused in a certain particular industry or a certain context in which there's evidence of that. You have to have some evidence of it, and usually it manifests itself in the numbers to some extent. Does that make sense?
Yes, thank you.
So let me correct what I said. I think in the educational context, that's no longer a good reason to remedy past discrimination, but in other contexts, that still exists, but it has to be very finely tuned. In that example, Crozon is a good example, C-R-O-S-O-N, Richmond County versus Crozon. It has to do with the fact that you have to narrowly confine, you have to find the group that's discriminating and only apply the program to that group. Julian's giving us a high sign. Either that or he's hungry.
Thank you so much to Judge Chen for
Thank you.